This is what it sounds like to beg Ron DeSantis to spare my uncle's life.
Because Florida law requires both people to consent to being recorded, I did not have permission. I had to re-record this part as a voiceover to stay legal. I'm leaving the video footage of my reaction to the phone call.
Hello, my name is Natalie, and I'm calling as the niece of Sergeant Jeffrey Glenn Hutchinson, a veteran, a beloved uncle, and a man your office has scheduled to be executed on May 1st. I was 6 years old when my uncle was arrested. For 27 years, I've waited and prayed, begged really, for his full story to be told in a courtroom, but that day has never come. As a child, I knew in my heart he was innocent. As an adult, after piecing together the court documents myself, I know it with certainty. The blood spatter on his body was inconsistent with firing a weapon. Alien DNA was found under his fingernails and never tested. There was no gunshot residue on his hands. Both the front and back doors of the home showed clear signs of forced entry, but none of that was ever introduced to the jury. Jeff had defensive wounds. He had burns on his face from the barrel of a shotgun, the same kind of shotgun he described being attacked with during the armed struggle, a Remington 870. That's not just consistent with his story, it confirms it. And yet the state relied on a 911 call identified by two people, strangers who had only known Jeff for 3 weeks. Those two witnesses, Creighton and Deanna Adams, were under federal investigation at the time for a series of bank robberies in Paxton, Florida, involving, yes, a Remington 870 shotgun. The state knew this. They let those individuals test unvetted, unchallenged, and without disclosing their conflicts of interest. The shotgun shown to the jury wasn't Jeff's. It wasn't a weapon used, but it was brandished in the court for effect, to intimidate. The judge repeatedly cocked the shotgun in front of the jury and let that image decide his fate. Jeff's state-appointed attorneys never had tried a death penalty case. They'd begged to withdraw and were forced to stay. Jeff was shackled. He was silenced with an electric stun belt. He tried to testify, to speak in his own defense. He was shocked into submission. Not a single family member, although there was 15 at the trial, and friends were called. Not a single expert, not even Jeff. Last week, my father visited him. Jeff had said, "I've been shot, I've been stabbed, I've been blown up by bombs, I've been gassed by chemical weapons during my deployment in the Gulf War, but I would never hurt my family." He said this from the very beginning. We've believed him every single day. But Florida's legal system didn't just take Jeff's freedom, it took everything from our family. It bankrupted my grandparents. Each appeal costed over $80,000, and still Jeff was barred from any real federal habeas review because of a missed filing deadline, and technicalities that had nothing to do with truth. The weight of it, the injustice, the helplessness, it took my grandfather's life in 2009. He died never knowing if his son's name would be cleared. Florida State Prison allotted Jeff an 8-minute phone call to hear the news. As for me, I grew up inside this broken system. I carry the trauma I never asked for. At ages 10 and 14, I was sexually objectified by correctional officers during visits to Florida State Prison. I did not have the language for it back then, but I knew it felt wrong. And I know now that trauma was a symptom of a system that is not designed to protect the innocent, or the vulnerable, or the families. Still, Jeff never gave up hope. He wrote to us, he encouraged us, and he reminded us to believe. When I was just 10, Jeff told me, "When you get onto death row, you realize how many men in here are innocent." He wasn't exaggerating. Since 1973, at least 197 people have been exonerated from death row in the United States. 30 of them were in Florida. Florida leads the nation in wrongful death sentences. This is not rare, this is not isolated, this is systemic. Florida's process traps people in endless appeals while barring them from exercising the very habeas rights that are supposed to protect all Americans. It builds a procedural cage so tall and tight that the truth itself cannot get through. But it's not too late. Governor DeSantis still has the power to act. Issuing a stay is not an admission of failure. It is an act of leadership, of courage, of humanity. We are not asking for special treatment. We are asking for time to review the evidence, time to make sure we are not executing a man who has been telling the truth for 27 years. Florida got this case wrong. What matters is what happens now.
See FADP for actions.